The sound echoed through courtroom 4C like breaking glass. Not the dignified murmur of judicial proceedings, but something uglier, something venomous. Look at her sitting there like she actually belongs in decent company. The voice belonged to Detective Gage Morton, whose bristly mustache and cheap polyester suit screamed corruption louder than any confession. He leaned toward his partner in the third row, making no effort to lower his voice. The acoustics of the old courthouse carried his words like a public announcement. 25 to life's gonna humble that attitude real quick. These women think they can play in a man's world and get away with it. Detective Wells Hart's response carried the satisfied tone of a man watching his favorite team score. These weren't whispers between colleagues. They were performances designed to be overheard, to intimidate, to remind a black woman exactly where she stood in their version of Baltimore justice. McKenna Brooks sat perfectly still at the defense table, her hands folded with the precision of someone who had learned that every gesture would be interpreted as either guilt or defiance. Her dark blazer was pressed, her posture straight, her expression unreadable. The two Baltimore detectives in the third row weren't trying to hide their amusement. To them, this was entertainment, free theater, a black woman about to learn her place. The case file lay open before Prosecutor District Attorney Quentin Webb like a roadmap to victory. According to Baltimore Police Incident Report number 2024-7743, filed August 15th at 14:32 hours, Detective Morton had discovered $200,000 in unmarked bills hidden in the false bottom of a shipping container at Brooks Logistics Solutions. The container was sealed when you arrived. McKenna's voice cut through the courtroom's stale air with the clarity of a tuning fork. Not loud, but precise. Each word measured, calculated for maximum impact. "Oh, she speaks." Morton's voice dripped with theatrical surprise. "Tell us more about your sealed container, sweetheart. Maybe you can explain how money just magically appeared there." The patronizing endearment landed like a slap. Several jurors shifted uncomfortably. Even in Baltimore, where casual racism often hid behind legal procedure, Morton's contempt felt unusually raw. But the lock mechanism showed two distinct click patterns, then complete silence on the security audio. Something they didn't expect her to know. 3 months earlier, McKenna had been running Baltimore's most efficient small logistics company. She arrived at her warehouse every morning at precisely 5:47 a.m., checked every shipment manifest twice, and maintained digital records with corporate-level precision that impressed even federal inspectors. Her employees noticed she never needed to check files. Every number, every date, every regulation seemed permanently etched in her mind like computer code. The habit extended beyond business necessity. She organized paperwork with military precision, filed documents in color-coded systems, and kept backup records in multiple formats. Her desk remained spotless, her supplies arranged in perfect rows, and her daily schedule followed routines that never varied by more than minutes. The discipline was so ingrained that employees joked she must have learned organization in the military. The Riverside Industrial District stretched along Baltimore's eastern edge, where small businesses fought daily battles against rising rents, changing regulations, and the constant threat of obsolescence. Brooks Logistics occupied a corner building that had housed 3 failed companies before McKenna transformed it into something approaching prosperity. Her neighbors ran auto repair shops, printing companies, and family restaurants, the backbone of honest commerce. These weren't corporate giants with teams of lawyers and political connections. They were businesses that employed local families, paid city taxes without complaint, and closed when their owners couldn't compete with forces beyond their control. Lately, several forced closures had involved mysterious violations, discovered by Detective Gage Morton. The first sign of trouble came when Morton visited for what he called a routine compliance check. His eyes swept over her modest office with undisguised condescension. The walls displayed business licenses, shipping certifications, and safety awards in frames that cost more than most people spent on decorations. "Nice little operation you got here. Must be tough for someone like you keeping track of all these complicated shipping rules." The pause before complicated carried enough implications to fill a legal brief. Morton's tone suggested he was speaking to a child playing dress-up in an adult's office. His emphasis on "someone like you" made his meaning crystal clear to everyone present. This story shows how quickly the tables can turn when corrupt officials think they're untouchable. If you're enjoying this tale of justice served cold, make sure to hit that like button and let me know in the comments what you think should happen to corrupt cops who abuse their power. Your engagement helps these important stories reach more people who need to see them. McKenna had simply handed him her certification binder. Every permit, Every inspection report, every regulatory approval organized with methodical precision. The tabs were color-coded, documents filed chronologically, every signature authenticated with supporting documentation. Morton's smirk faltered as he flipped through pages of spotless compliance records. Detective Gage Morton had made a career of discovering evidence in unlikely places. His record showed an unusual pattern. Small business owners with clean backgrounds suddenly found themselves facing major felony charges. Over 18 months, he had personally initiated cases that resulted in 37 felony convictions. His success rate was impressive and suspicious. In the warehouse district, news traveled faster than Baltimore's notoriously slow internet. Word spread that McKenna Brooks was being investigated. The same Morton whose investigations had shuttered Rodriguez Auto Parts, Kim's Electronics Repair, and Thompson Family Catering. Some neighbors avoided eye contact. Others whispered that maybe they should distance themselves before becoming targets. The mathematics of survival were brutally simple. Customers avoided companies under investigation. Suppliers demanded cash from businesses that might not exist next month. Banks froze credit lines at the first hint of legal trouble. Even innocent business owners learned to treat police attention like a contagious disease. The second visit came 6 weeks later. This time, Morton brought Detective Wells Hart and a warrant to examine shipping records. Hart was Morton's complement. Where Morton preferred psychological pressure, Hart communicated through physical presence and implied threats. They spent 4 hours in her office, Hart copying files while Morton asked the same questions repeatedly. "What's the matter? Got something to hide?" Morton's question came after McKenna requested to see the warrant's scope. Her request was perfectly legal, entirely reasonable, and utterly predictable. But Morton treated it like evidence of guilt. "I want to ensure we're following proper procedure." Her response carried no emotion, no defensiveness, no indication she found Morton's implications offensive. This wasn't the behavior pattern Morton expected. Most people became nervous, apologetic, eager to please. They offered information that wasn't requested and generally behaved like people with something to hide. Listen to her. Proper procedure, like she went to law school or something. Hart's chuckle held enough contempt to fuel a discrimination lawsuit. His comment revealed assumptions about education, race, and social position that would have been explosive in different contexts. But this was a private office, officially documented as part of legitimate investigation. The visits became weekly, then twice weekly. New questions about the same shipments, the same clients, the same perfectly legal transactions approved by federal customs officials, state transportation authorities, and municipal licensing departments. The harassment was methodical, designed to wear down her composure through death by 1,000 bureaucratic cuts. "You know what I think? I think you're in over your head here. This isn't a game for people like you." Morton's strategy relied on simple premises. Most people couldn't afford extended legal battles with well-funded government agencies. Small business owners had 3 choices: fight and risk bankruptcy, flee and abandon years of investment, or cooperate and hope compliance would satisfy their tormentors. "Detective, your search exceeded the warrant's scope. Section 4.2 of the shipping manifest wasn't listed in your probable cause affidavit." Her observation stopped Hart mid-stride and caused Morton's jaw to visibly tighten. Most defendants couldn't cite Miranda rights accurately, let alone identify specific procedural violations in warrant execution. Her knowledge of legal terminology was unexpected and unwelcome. Wells Hart served as Morton's enforcement arm, handling persuasion that required physical presence rather than verbal threats. He began making solo visits, walking through the warehouse uninvited, examining containers without warrants, asking pointed questions about employee safety that made everyone nervous about continued employment. Hart's visits followed no predictable schedule. He might appear at 7 a.m. or 3 p.m., disrupting workflow, making customers uncomfortable, creating constant surveillance atmosphere that transformed routine operations into exercises in paranoia. Employees requested transfers. New hires declined offers after learning about the investigation. By the 8th week, 3 major clients had terminated contracts. Word was spreading through Baltimore's shipping industry that Brooks Logistics was under investigation for unspecified violations involving money laundering, tax evasion, or drug trafficking. In an industry where reputation determined survival, perception became reality faster than facts could travel. When the arrest warrant materialized, McKenna was assigned public defender Emerson Vale, a man so overwhelmed he confused her file with 3 others during their first meeting. His strategy was straightforward. Accept whatever plea deal prosecution offered, hope for minimum sentencing, move to the next case in his stack of 43 active files. Speaking of corruption and cover-ups, let's talk about protecting yourself from legal threats. Legal Shield provides 24/7 access to dedicated attorneys, for a fraction of traditional legal costs. Whether you're facing harassment, discrimination, or need contract reviews for your business, Legal Shield members get unlimited phone consultations with licensed attorneys. For less than $1 a day, you can have the legal protection that could save your business, your assets, and your peace of mind. Visit LegalShield.com/justice to get your first month free and join over 1 million Americans who refuse to face legal challenges alone. August 15th, 2024, 2:32 p.m. According to official police reports, Detective Morton's routine follow-up inspection of Container 7-Alpha revealed a hidden compartment in the false bottom containing $200,000 in unmarked bills matching serial numbers from a federal drug sting 3 days earlier. The discovery was recorded on body camera footage meeting all legal requirements for authentication. The timestamp was accurate, audio clear. Morton's surprised reaction appeared genuine as he called backup and documented what he described as the largest drug money seizure in my career. That container was under customs seal. Breaking that seal without federal oversight violates 19 U.S.C. Section 1595A. The evidence would be inadmissible. Her response demonstrated knowledge far beyond typical defendant preparation. Most people couldn't distinguish between state and federal jurisdiction, let alone cite specific statutory violations with section numbers. Her precision suggested either extensive coaching or personal familiarity with federal customs regulations. "What did you just say?" Morton's incredulous response revealed how thoroughly her knowledge had disrupted expectations. Hart stopped file examination to stare at a defendant behaving more like a law professor than a small business owner facing life imprisonment. Even Prosecutor Webb looked up with the expression of someone whose routine case had suddenly become complicated. Judge Dorian Thorne had presided over 17 cases involving Morton's evidence discoveries. All 17 resulted in convictions that enhanced his reputation for judicial efficiency. His courtroom operated like a well-oiled machine. Prosecutors presented evidence, defense attorneys made token objections, juries convicted, defendants received sentences satisfying tough-on-crime statistics. The defendant will refrain from legal commentary. You have counsel for that purpose. Thorne's rebuke was designed to re-establish courtroom hierarchy after McKenna's unexpected legal knowledge disrupted normal proceedings. Her citations suggested preparation beyond what public defenders typically provided, raising uncomfortable questions about her background. According to Warehouse Security Log WSL-2024-0815, recorded by Secure Watch Systems, Container 7-Alpha had been under continuous video surveillance from 0600 through 1800 hours. The timestamp showed Morton approaching at 14:15 hours, 17 minutes before the alleged discovery. The 17-minute gap would prove significant. 17 minutes was sufficient time to plant evidence, create false documentation, establish the narrative that would transform a legitimate shipping container into criminal evidence. Also sufficient time to make fatal mistakes that would destroy everyone involved. The security system records access attempts every 30 seconds. The log should show exactly when the container seal was broken. Her calm observation revealed knowledge of security protocols that impressed even the court reporter. Her familiarity with technical details suggested either extensive preparation or professional experience with evidence documentation beyond typical business operations. Should show, like you're some kind of expert on evidence collection? Hart's snorting dismissal carried enough contempt to power a generator. His response revealed assumptions about expertise, authority, and social position that would have been problematic in contexts involving actual legal scrutiny. "Mr. Vale, control your client. This court will not tolerate coached testimony." Thorne's warning targeted Vale, but its real focus was McKenna's knowledge exceeding what defendants in her position were supposed to possess. The suggestion that her observations constituted coached testimony revealed judicial bias that would have triggered immediate appeals in federal court. "Your Honor, my client was merely..." Vale's weak protest died under Thorne's withering glare. As a public defender with unlimited caseload, Vale couldn't afford to antagonize judges whose cooperation was essential for plea bargains that kept clients out of prison. Your client was attempting to obstruct legitimate police work. The evidence stands as presented. Thorne's ruling eliminated any possibility that procedural violations would interfere with Morton's case. His dismissal carried judicial authority, effectively preventing jury consideration of evidence contradicting prosecution narrative. Juror number 7, Brenna Wade, shifted uncomfortably as the exchange unfolded with uncomfortable intensity. The defendant's knowledge seemed unusual, but Thorne's dismissal felt hasty for a case involving potential life imprisonment. Several jurors exchanged glances suggesting the standard narrative wasn't fitting observed evidence. Brooks Logistics had employed 12 people when McKenna was arrested. By trial time, 8 had found other jobs. The remaining 4 worked without pay, hoping their employer would survive the legal nightmare destroying 23 years of business development. The Baltimore Shipping Association had temporarily suspended her membership pending resolution of criminal charges not yet filed. Without that membership, she couldn't bid on municipal contracts, steady income streams keeping small logistics companies solvent during economic downturns. Local news followed predictable crime reporting patterns, prioritizing sensational headlines over investigative journalism. Small business owner charged with money laundering appeared on page 3 with no mention of procedural questions, no investigation of timeline discrepancies, no context about similar cases involving Morton's investigations. Mr. Vale, your client faces 25 years on state charges, but if we find evidence of interstate commerce violations, we'll be looking at federal RICO prosecution. Life imprisonment is not off the table. Webb's threat was calculated to force immediate plea bargains before federal agencies could examine the case for constitutional violations. RICO prosecution was particularly effective because it suggested organized crime connections justifying asset forfeiture targeting Brooks Logistics' entire operation. I understand the charges, Your Honor. I maintain my innocence. McKenna's voice never wavered, never cracked, never betrayed emotional stress normal for someone facing life imprisonment. No tears, no pleading, no dramatic outbursts, just steady, unshakable certainty that truth would eventually surface. Her composure was unnatural enough to make everyone uncomfortable. Innocent defendants usually displayed obvious distress when confronted with major felony evidence. Guilty defendants showed panic when alibis fell apart. McKenna's calm suggested either sociopathic detachment or confidence based on undisclosed knowledge. The gallery remained nearly empty except for Morton and Hart, who attended every session like spectators at predetermined sporting events. Their presence served multiple purposes: intimidating the defendant, demonstrating police confidence, providing moral support for Webb's conviction efforts. Their laughter had become the soundtrack to McKenna's legal proceedings, punctuating every prosecution victory with satisfaction sounds that echoed through the courtroom like audio evidence of systemic bias. The acoustics carried their amusement directly to the jury box, reinforcing impressions about defendant guilt and appropriate community response. Watching McKenna face this rigged system reminds us why we can never stay silent when we see injustice. If this story is hitting you as hard as it's hitting me, please share it with someone who needs to see that even the darkest corruption can be brought into the light. Hit that subscribe button too. We're building a community that believes justice should never depend on your skin color or bank account. Prosecution had invited local business leaders to observe proceedings as demonstration of their commitment to fighting commercial crime undermining legitimate economic development. The message was strategically clear: challenge Baltimore law enforcement, face public humiliation before inevitable conviction. Ladies and gentlemen, you're witnessing exactly the kind of corruption that undermines honest business in Baltimore. While you pay taxes and follow regulations, defendants like Ms. Brooks exploit their operations to launder drug money. Webb's address transformed the courtroom into public theater where McKenna's guilt was presented as established fact rather than legal theory requiring proof. His characterization resonated with business leaders who had struggled to compete with companies that seemed to operate under different rules. McKenna sat motionless as Webb painted her as a sophisticated criminal who had deceived banks, suppliers, customers, and regulatory agencies through carefully constructed facades hiding international money laundering operation. Her employees winced at accusations transforming routine work into criminal conspiracy evidence. But their employer never looked back, never showed weakness, never gave enemies satisfaction of seeing her break. Ms. Brooks, on March 15th, what was the contents of Container 2-Charlie? Webb's question was designed to test memory under pressure, hoping she would hesitate, request documents, or provide inconsistent information for impeaching credibility. Most defendants couldn't recall specific details from months-old transactions, particularly complex shipping manifests with multiple components and destinations. Automotive parts, manifest number ATM-2024-0315. Shipper, Detroit Manufacturing Solutions. Recipient, Baltimore Auto Supply, 2247 Eastern Avenue. Declared value, $47,300. Her response rattled off details from 5-month-old shipments with computer precision, without notes, without hesitation, without indication the information required conscious effort to recall. The detail level suggested either photographic memory or preparation far beyond typical defendant coaching. Webb had expected confusion, uncertainty, perhaps requests to review records allowing him to control information revelation pace. Instead, He faced a defendant whose business knowledge exceeded what most executives could provide about their company's activities. Juror number 3, Camden Morrison, leaned forward with the expression of someone whose assumptions were being systematically challenged. As a small business owner, he understood the impossibility of memorizing manifest details for months-old transactions. That kind of recall suggested either extensive preparation or professional expertise beyond normal commercial operations. Assistant District Attorney Lila Fairbanks had joined the prosecution team specifically for this case, bringing specialized expertise in destroying defendant credibility through character assassination techniques proven effective in previous high-profile trials. Her approach involved requesting unnecessary document reviews, forcing extended court sessions, creating procedural complications designed to exhaust McKenna's minimal legal resources. Fairbanks understood that public defenders like Vail couldn't afford prolonged battles with well-funded prosecution teams. Her strategy involved making cases so expensive and time-consuming that even innocent defendants would accept plea bargains rather than risk bankruptcy through extended litigation. According to Brooks Logistics' audited financial statements, prepared by certified public accountant Williams & Associates, gross revenue for fiscal year 2023 was $847,000. Net profit after taxes and operational expenses, $67,000. The margins were typical for small logistics operations competing on service quality rather than volume discounts. The records revealed a company operating within normal parameters for businesses of its size and market position. No evidence of hidden income streams, unexplained cash deposits, or accounting irregularities suggesting money laundering operations. The books showed exactly what they appeared to show: a modest but successful company generating reasonable profits through legitimate activities. The Baltimore Business Improvement District held emergency meetings to discuss the Brooks case and its implications for other small businesses. Some members wanted to publicly support McKenna, believing charges were racially motivated harassment designed to eliminate successful minority-owned businesses. Others worried that association with defendants facing federal money laundering charges would invite similar investigations. The split reflected broader tensions about police authority, racial justice, and appropriate responses to cases apparently targeting specific business owner types. Discussions revealed fears that cooperation with law enforcement might not provide protection from arbitrary enforcement actions destroying decades of development through difficult-to-disprove accusations. Judge Thorne had noticed something troubling about defendant responses throughout proceedings. Her legal knowledge was too precise, too sophisticated for someone supposedly represented by an overworked public defender with limited preparation resources. Either she had received extensive coaching from undisclosed sources, or they were missing something significant about her background. The possibility that McKenna possessed legal training or professional expertise not disclosed to the court raised uncomfortable questions about prosecutorial due diligence and defense strategy. If she had relevant qualifications being concealed for tactical reasons, the entire case might be built on false competence and resource assumptions. You know, accidents happen in places like this. Forklifts malfunction, containers fall. Would hate to see your people get hurt while this investigation continues. Hart's warehouse visit was officially documented as follow-up security inspection, but his safety comments carried implications unrelated to regulatory compliance. The threat was carefully phrased to be deniable if recorded, but unmistakably clear to McKenna, and employees' understanding that cooperation was no longer optional. The psychological warfare was designed to force plea bargain negotiations before jury trial, where unpredictable factors might interfere with prosecution control over outcomes. Hart's warehouse presence reminded everyone that police authority extended beyond courtroom proceedings into daily business operations under investigation. We've identified shipments to Delaware, Pennsylvania, and Virginia. Interstate transportation of illegal proceeds escalates this to federal jurisdiction. The FBI has been notified. Webb's announcement was calculated to increase defense pressure by suggesting state charges were only the beginning of McKenna's legal troubles. Federal involvement mentions were standard prosecution intimidation designed to force immediate plea bargains before outside agencies could complicate cases with jurisdictional disputes or constitutional challenges. The threat carried weight because federal money laundering sentences typically exceeded state penalties, and federal courts operated under different rules providing fewer defense maneuvering opportunities. Most defendants would have immediately requested plea bargain negotiations rather than risk federal prosecution exposure with superior resources and harsher sentencing guidelines. But Webb's bluff would prove prophetic in ways he couldn't anticipate. Federal agencies were indeed interested in the case, but not for assumed reasons. The FBI had been monitoring Baltimore Police Department practices for constitutional violation patterns, and McKenna's case had triggered multiple red flags and algorithms designed to detect systematic civil rights abuses. The Maryland Department of Transportation had temporarily suspended Brooks Logistics' commercial transportation license pending criminal charge resolution, not yet resulting in convictions. Without that license, the company couldn't legally operate, meaning McKenna couldn't generate revenue for legal fees or business maintenance during extended litigation. The suspension created catch-22 situations where defending against criminal charges became impossible without income from business operations prohibited during legal processes. Administrative procedures were designed to force rapid plea bargain resolutions before defendants could mount effective resistance to prosecution narratives that might not survive sustained scrutiny. Ms. Brooks, you claim these shipping manifests are accurate. Can you explain the discrepancy in container weights between initial loading and final destination? Fairbanks's question was designed as a trap, assuming McKenna couldn't provide technical explanations for normal shipping weight variations occurring during transportation. Most defendants would have requested expert consultation or acknowledged ignorance about complex logistics procedures requiring specialized understanding. Container 4-Delta showed weight variance due to moisture absorption during the 48-hour hold at Port of Baltimore. Standard procedure accounts for up to 3% weight fluctuation under Maritime Code Section 12.4.7. Her response demonstrated knowledge of federal maritime regulations that Fairbanks herself didn't possess. The specific code section citation revealed familiarity with regulatory frameworks beyond typical business operations, suggesting either extensive preparation or professional training in federal compliance procedures. Fairbanks's confident smirk vanished as she realized her trap had backfired spectacularly. She had expected the defendant to stumble over technical shipping regulations that could suggest incompetence or deception. Instead, McKenna had demonstrated expertise, making the prosecution team look unprepared by comparison. How do you know that regulation? Vale's whispered question revealed confusion about his client's legal knowledge. Most defendants required extensive coaching to understand basic courtroom procedures, let alone federal maritime law governing international shipping operations. Her familiarity with regulatory details suggested preparation beyond typical public defender resources. I've been in logistics for 23 years. You learn the rules. Her response was technically accurate but incomplete in ways Vale couldn't suspect. 23 years provided extensive practical experience, but memorizing specific regulatory code sections required either exceptional memory or professional training beyond normal commercial operations. Vale had handled shipping cases before and knew that most logistics operators understood basic regulations without memorizing specific statutory citations. McKenna's knowledge suggested education or training beyond what her business background should have provided, but he lacked resources to investigate discrepancies that might help or harm her defense. During recesses, Morton approached Webb at the prosecution table for hushed conversations growing more animated as trial progressed. Hart joined these strategy sessions, producing manila envelopes containing documents not included in official case files. They were coordinating approach in real time, adjusting tactics as the defendant proved more formidable than initial assessments predicted. Police-prosecutor collaboration was normal in criminal cases, but their coordination intensity suggested concerns about case developments not being disclosed to defense counsel. Their behavior indicated either unusual complexity in what should have been straightforward money laundering prosecution or evidence problems requiring careful management. According to cell phone records subpoenaed by defense through procedural motions that Vale filed at McKenna's specific direction, Morton had made 17 calls to an unlisted number during the week preceding her arrest. Each call lasted between 37 and 42 seconds. Precise duration of status reports to supervisory personnel preferring brief, coded communications minimizing surveillance exposure. The pattern suggested coordination with parties not identified in official case documents, raising questions about investigation scope and federal agency involvement not disclosed to defense counsel. Call timing corresponded to significant case developments, indicating someone outside immediate investigation was monitoring progress and providing guidance. Knox Thompson, who owned Thompson Automotive Repair 3 blocks away, appeared in the gallery during trial's second week. Then Sloan Blake from Blake's Family Restaurant joined him. Then Reeve Sterling from Sterling Printing. Small business owners understanding the implications began attending sessions that would determine whether police authority could destroy legitimate businesses through fabricated criminal charges. Their presence represented more than moral support. It demonstrated community recognition that her case had implications beyond individual justice. If police could destroy Brooks Logistics through planted evidence and prosecutorial manipulation, and no small business in the district was safe from similar treatment, whenever authorities decided certain types of economic development were no longer welcome. Business owner attendance didn't go unnoticed by prosecution counsel, who understood that community support could influence jury perceptions about police credibility and case legitimacy. Their visible presence suggested that McKenna's prosecution was being interpreted as part of broader harassment patterns threatening the entire small business community. During jury selection, potential jurors had been told this was straightforward money laundering involving clear evidence discovered through routine police work. But defendant responses suggested complexity that neither prosecution nor defense had adequately explained during preliminary proceedings. The disconnect between promised simplicity and observed complexity was creating doubt about initial case presentation accuracy. Juror number 7 passed a note requesting additional evidence about container security procedures and federal customs regulations. Her question indicated that jury deliberations might focus on technical details prosecution counsel had assumed would be beyond typical juror comprehension. Interest in procedural specifics suggested McKenna's legal knowledge was having intended impact on jury perceptions. These profit margins seem suspicious for a logistics company. Fairbanks' suggestion was designed to imply that Brooks Logistics' financial performance indicated hidden income sources not disclosed to tax authorities or business regulators. Her comment assumed jurors wouldn't understand normal small shipping company profit margins and could be convinced that modest success indicated criminal activity. Industry standard for small logistics operations ranges from 6 to 12% gross margin. Our 7.9% falls within normal parameters established by the National Association of Small Freight Companies. McKenna's response quoted industry statistics with decimal precision, demonstrating knowledge of commercial benchmarks exceeding what most business owners possessed about their own operations. Her ability to contextualize company performance within industry standards revealed preparation or expertise, contradicting prosecution characterizations of her as an unsophisticated criminal defendant. Fairbanks hadn't expected statistical analysis from someone supposed to be relying on an overworked public defender for legal guidance. The response demonstrated competence, making prosecution narrative increasingly difficult to maintain, while raising questions about McKenna's background that nobody seemed prepared to answer. You know what McKenna needed? Financial protection from predatory schemes. That's where LifeLock comes in. Identity thieves and financial scammers target small business owners like McKenna every single day. LifeLock monitors your personal information across the dark web, data breaches, and financial institutions. They've helped prevent billions in identity theft losses, and if your identity is stolen while you're protected, they'll work to fix it. Right now, you can save up to 25% on LifeLock plans. Visit lifelock.com/protect and use code JUSTICE to secure your financial future before criminals target you next. Mr. Vale, we're filing a motion under 42 U.S.C. Section 1983 alleging civil rights violations in the evidence collection process. Vale's reluctant announcement represented significant escalation in defense strategy, transforming a state money laundering case into federal constitutional litigation. The motion alleged systematic Fourth Amendment violations against unreasonable searches and 14th Amendment due process guarantees that could invalidate all evidence obtained through police misconduct. Mr. Vale, that's a very serious accusation. Do you have evidence of federal civil rights violations? Thorne's question revealed judicial concern about allegations that could trigger federal oversight of his courtroom and personal liability for judges knowingly participating in constitutional violations. Federal civil rights cases attracted attention from agencies with power to investigate, prosecute, and discipline state court officials facilitating systematic rights deprivations. Vale looked at his client, who nodded almost imperceptibly in a gesture suggesting coordination between attorney and client, exceeding normal public defender relationships. Her guidance had been steering his legal strategy from the beginning, feeding him procedural knowledge he didn't possess and directing motions more sophisticated than his typical case management. You're making this harder than it needs to be. Smart people know when to accept reality. Morton's approach to McKenna after court sessions violated protocols prohibiting police contact with represented defendants outside counsel presence. His comments constituted witness intimidation that could trigger federal charges carrying penalties exceeding anything McKenna faced from state prosecution. Detective, are you threatening me outside a federal courthouse? Because that would violate 18 U.S.C. Section 1512, witness intimidation. Her response accused Morton of federal felony charges while citing exact statutory sections that most lawyers couldn't recite from memory. The precision of her legal knowledge combined with her ability to recognize federal crimes in progress suggested training far beyond typical business education. Morton's face went pale as he realized his intimidation attempt had been recorded and documented by someone understanding federal criminal law well enough to build cases against law enforcement officials. Her response indicated competence, making him profoundly uncomfortable about assumptions underlying his investigation. Maybe you should reconsider your attitude. Accidents happen to people who don't know their place. Hart's physical intimidation escalated the confrontation beyond verbal threats into assault territory that could trigger federal charges for rights deprivation under color of law. His use of size and proximity to threaten a criminal defendant outside a federal courthouse demonstrated either remarkable stupidity or remarkable arrogance about police immunity from prosecution. But McKenna didn't step back, didn't show fear, didn't display behavioral responses that Hart's intimidation tactics were designed to provoke. Instead, she pulled out her phone and began recording with calm efficiency of someone who had anticipated this confrontation and prepared accordingly. Detective Wells Hart, badge number 1847, is physically blocking my exit from Baltimore Federal Courthouse at 3:47 p.m., August 29, 2024. This constitutes witness intimidation under federal statute. Her recording created legal evidence with timestamp and badge identification demonstrating professional understanding of evidence collection procedures. She wasn't just documenting police misconduct. She was building a federal case with precision of someone trained in law enforcement techniques. Hart's confidence evaporated as he realized his intimidation attempt had been transformed into evidence of federal crimes that could destroy his career and freedom. The defendant he had dismissed as powerless was demonstrating competence, suggesting resources and knowledge that none of them had suspected. Other people leaving the courthouse stopped to watch the confrontation unfold, with several beginning to record on phones as they recognized the significance of what was happening. What had started as private intimidation was becoming public incident with multiple witnesses and documentation that would be difficult for police to explain or dismiss. According to courthouse security footage, timestamp 15:47:23, Hart made physical contact with the defendant at the courthouse exit in an incident recorded on Federal Protective Service cameras and automatically archived under case file FPS-2024-1847. The federal documentation created official records accessible to agencies with civil rights violation jurisdiction. Mr. Vale, I've received a formal complaint about officer conduct outside this courthouse. The Federal Protective Service is conducting an investigation. We will proceed with trial, but any further incidents will result in contempt charges. Thorne's warning the following day revealed that federal authorities were now monitoring his courtroom for constitutional violations that could trigger federal intervention in state court proceedings. His mention of Federal Protective Service indicated that agencies with power to prosecute police misconduct were actively investigating the case. The judge's warning wasn't just about contempt. It was about federal agencies watching his courtroom for systematic constitutional violation evidence that could result in federal prosecution of state court officials facilitating civil rights deprivations. Thorne understood that his judicial conduct was now under federal scrutiny that could destroy his career if investigators found bias or misconduct evidence. Your Honor, the prosecution's timeline shows Detective Morton discovering evidence at 14:32 hours, but warehouse security logs show he entered the facility at 14:15 hours. The 17-minute gap is unexplained. Vale's observation, guided by McKenna's security protocol knowledge, identified critical discrepancy in prosecution evidence undermining the entire case narrative. The 17-minute gap was sufficient time to plant evidence and create false documentation, meaning the prosecution's timeline contained internal contradictions suggesting police misconduct. Minor discrepancies in timekeeping are normal. Webb's flustered response revealed prosecutorial concern about timeline problems he hadn't anticipated during case preparation. His dismissal of 17-minute discrepancies as minor suggested either incompetent investigation or deliberate concealment of evidence contradicting official police reports. 17 minutes is sufficient time to plant evidence and create false documentation. McKenna's interruption violated courtroom protocol but successfully planted the idea that prosecution evidence might be fabricated rather than discovered. Her timing was perfect. The comment came after Webb's weak explanation had already raised juror suspicions about timeline problems that prosecution counsel couldn't adequately address. The magic words had been spoken: constitutional violations. Under federal law, any systematic denial of constitutional rights became a civil rights case with federal jurisdiction superseding state court authority. McKenna had just escalated her case beyond state prosecution control into federal territory where different rules and more powerful agencies would determine outcomes. What started as local money laundering prosecution was now attracting attention from the Federal Bureau of Investigation, the Civil Rights Division of the Department of Justice, and Internal Affairs Departments of Baltimore Police, specializing in investigating systematic misconduct by law enforcement personnel. The accumulation of federal violations was making it impossible for this to remain a state matter much longer. The federal interest wasn't coincidental. It was the result of ongoing investigation into police practices that had been generating suspicious statistical patterns for 18 months. Morton's conviction rate was mathematically improbable unless he possessed investigative skills exceeding normal human capabilities or access to evidence not obtained through legal procedures. Special Agent Bryce Cross of the FBI's Public Corruption Unit had been monitoring Baltimore Police Department cases for patterns of constitutional violations that indicated systematic rather than individual misconduct. McKenna Brooks's case had triggered multiple red flags in Bureau algorithms designed to detect coordinated civil rights abuses by law enforcement personnel operating under color of state authority. The Bureau's interest wasn't coincidental. It was the result of ongoing federal investigation into police practices generating suspicious statistical patterns for 18 months. Morton's conviction rate was mathematically improbable unless he possessed investigative skills exceeding normal human capabilities or access to evidence not obtained through legal procedures. Cross had built his career identifying institutional corruption disguised as exceptional police work. According to FBI Digital Forensics Analysis, Report DF-2024-5847, Detective Morton's body camera showed anomalous timestamp gaps during container inspections that couldn't be explained by normal equipment malfunctions or user error. 3 separate intervals totaling 4 minutes and 17 seconds contained no audio or visual data, indicating deliberate editing designed to conceal activities occurring during evidence collection procedures. The technical analysis revealed sophisticated evidence manipulation requiring knowledge of body camera systems and access to editing equipment not available to individual patrol officers. The scope of technical support suggested institutional involvement in evidence fabrication extending beyond individual misconduct to systematic police corruption involving multiple personnel and supervisory approval. Federal subpoenas of Baltimore Police Department servers revealed encrypted email threads between Detective Morton and Assistant DA Fairbanks discussing evidence placement strategy and defendant profile management in language clearly indicating coordination between police and prosecutors in fabricating criminal cases against targeted individuals. The emails, authenticated by FBI cybercrime specialist Agent Peyton Hartwell, provided evidence of conspiracy violating federal statutes carrying penalties exceeding state criminal charges. The email evidence transformed individual misconduct allegations into federal conspiracy charges that could result in decades of prison time for everyone involved in the plot to frame McKenna Brooks. The language used in police-prosecutor communications revealed systematic corruption operating under official cover for extended periods, targeting multiple victims through coordinated law enforcement abuse. The FBI had contacted 12 other small business owners who had faced similar charges after Detective Morton investigations, and 7 reported identical patterns of unexpected inspections, planted evidence, and prosecution offers for plea bargains that included business asset forfeiture procedures. The consistency of tactics indicated systematic rather than individual corruption, triggering federal jurisdiction over civil rights violations that couldn't be addressed through state court procedures. Cross understood that successful prosecution of police corruption required witnesses with credibility, documentation skills, and courage to testify against law enforcement personnel who possessed power to destroy lives through false criminal charges. McKenna Brooks had demonstrated all 3 qualities, making her uniquely valuable as a federal witness against systematic constitutional violations. Ms. Brooks, your cooperation with this federal investigation is noted. We appreciate your detailed documentation and legal knowledge. Cross's tone carried unusual respect for someone supposedly a criminal defendant in state court proceedings. Federal agents didn't typically defer to defendants in local cases, which suggested that McKenna's relationship with federal authorities differed significantly from what state prosecutors had assumed. Her cooperation had been extensive, careful, and professionally executed. The agent's acknowledgement of her cooperation and detailed documentation revealed that she had been working with federal investigators in ways not disclosed to state court participants. Her legal knowledge and evidence collection skills were being praised by federal agents who understood the quality of her contributions to their investigation of systematic police corruption. Surveillance of Detective Hart revealed 3 meetings with Assistant DA Fairbanks at locations away from official facilities, with each meeting occurring within 48 hours of significant developments in McKenna's case. The pattern indicated ongoing conspiracy to manipulate legal proceedings through coordination between law enforcement and prosecution personnel supposed to operate independently. The surveillance evidence showed that police and prosecutors were coordinating strategy outside official channels, violating ethical rules and constitutional requirements for independent investigation and prosecution of criminal cases. Their secret meetings provided evidence of systematic corruption extending beyond individual misconduct to institutional abuse of governmental authority. Baltimore Sun investigative reporter Tessa Walsh began examining Detective Morton's case history after receiving anonymous tips about unusual patterns in his conviction statistics. Her preliminary research identified 47 convictions based on his evidence discoveries over 18 months, representing a success rate statistically impossible without either exceptional luck or systematic evidence manipulation. Walsh's investigation revealed that Morton's cases followed identical patterns of evidence discovery, witness intimidation, and rapid plea bargain resolution, suggesting coordination rather than individual investigation. Her analysis of court records and police reports identified procedural similarities indicating systematic rather than coincidental patterns in case development and resolution. Her reporting would later reveal that federal investigators had been feeding her information to build public pressure for accountability while protecting ongoing criminal investigations. Walsh's journalism served as cover for federal operations targeting police corruption that required public support to overcome institutional resistance to outside oversight. Can you believe what we just witnessed? Those smug faces are about to change real fast. If you're on the edge of your seat wondering how deep this corruption goes, make sure you're subscribed with notifications turned on. The next few minutes are going to expose a conspiracy that reaches higher than anyone imagined. Drop a comment if you think you know what's coming next. FBI Financial Crimes Unit analysis of Baltimore Police Department asset forfeiture accounts revealed irregular patterns that couldn't be explained by normal law enforcement activities. According to bank records subpoenaed under federal warrant SW-20 24-0892, Detective Morton's cases had generated $2.3 million in seized assets over 18 months, 5 times the departmental average for similar investigations. The financial analysis revealed that asset forfeiture proceeds from Morton's cases were being distributed through channels differing from standard police department procedures. The money was flowing to accounts not subject to normal oversight, suggesting that seized assets were being diverted for purposes unrelated to legitimate law enforcement activities. Cross's team discovered that forfeiture proceeds were funding off-books operations including surveillance equipment, informant payments, and personal expenses that wouldn't have been approved through normal departmental budgeting processes. The financial irregularities indicated corruption extending far beyond individual officers to systematic abuse of asset forfeiture laws designed to support legitimate law enforcement. The pattern was unmistakable. Small businesses, minority owners, minimal legal representation, and rapid plea bargain pressure resulting in asset forfeiture without extended litigation. Each case followed identical procedures, suggesting institutional knowledge rather than individual initiative, indicating that systematic corruption involved multiple participants operating under official cover. Statistical evidence revealed targeting patterns that couldn't be explained by random crime distribution or normal investigative procedures. The concentration of cases involving minority-owned businesses with limited legal resources suggested deliberate selection based on vulnerability rather than evidence of criminal activity. Ms. Brooks, we've confirmed violations of 18 U.S.C. Section 242, deprivation of rights under color of law. Additionally, 18 U.S.C. Section 371, conspiracy against rights, and potential RICO violations under 18 U.S.C. Section 1962. Cross's recitation of federal charges revealed that police and prosecution personnel were facing criminal penalties far exceeding anything McKenna had been threatened with under state prosecution. The federal charges carried maximum sentences that would effectively end the careers and freedom of everyone involved in the conspiracy against her business. The transformation was complete. The hunters had become the hunted, and the people who had laughed at her legal knowledge were about to discover that she understood federal criminal law better than they understood their own exposure to prosecution for systematic constitutional violations. Counselors, I've been informed that federal authorities are investigating this case for civil rights violations. We will proceed with state proceedings, but I'm advising all parties that federal agencies have concurrent jurisdiction. Thorne's warning was strategically important because it informed everyone that federal charges could supersede state proceedings if investigators found evidence of systematic constitutional violations. His advice that federal agencies had concurrent jurisdiction meant that state court conviction wouldn't protect anyone from federal prosecution for the same underlying conduct. The judge's statement revealed that he had been contacted by federal authorities monitoring his courtroom for evidence of judicial participation in constitutional violations. His careful legal language suggested awareness that his own conduct was under federal scrutiny that could result in criminal charges if investigators concluded he had knowingly facilitated civil rights violations. "We remain confident in our evidence. Ms. Brooks may have federal agents asking questions, but that doesn't change the facts of her case." Webb's statement to media was calculated to suggest that McKenna was simply receiving unexpected federal attention rather than actively cooperating with agencies investigating systematic police corruption. His confidence was designed to minimize public perception that prosecution evidence might be fabricated or that federal authorities had discovered misconduct invalidating state criminal charges. The prosecutor's public comments revealed ignorance about the actual scope of federal investigation and McKenna's role in documenting constitutional violations that had been occurring for months before her arrest. His assumption that federal interest was recent and superficial would prove catastrophically wrong in ways he couldn't have anticipated. "Ms. Brooks, how did you know to document everything so precisely? Most clients don't understand chain of custody requirements." Vale's confused question revealed growing awareness that his client possessed legal knowledge exceeding what public defenders typically encountered from criminal defendants. Her understanding of evidence documentation procedures suggested either extensive legal training or professional experience with law enforcement that she hadn't disclosed during attorney-client consultations. 23 years in logistics teaches you to keep careful records. Her response was technically accurate but deliberately incomplete, in ways Vale couldn't have suspected without information about her cooperation with federal authorities. Her answer avoided revealing the extent of her collaboration with agents who had been training her in evidence collection procedures that would support federal prosecution of police corruption. Vale didn't know he was representing someone whose cooperation with federal investigations had been carefully orchestrated for maximum impact against systematic corruption extending far beyond her individual case. Her documentation skills had been developed through months of collaboration with federal agents who understood that her case could provide evidence of institutional misconduct affecting dozens of other victims. The question that nobody in the state courtroom was prepared to answer had been carefully concealed through coordination between federal investigators and a defendant who possessed professional qualifications, making her uniquely valuable as a witness against police corruption. Her legal knowledge wasn't accidental. It was the result of intensive preparation designed to document constitutional violations that could support federal prosecution of systematic civil rights abuses. But there was more to McKenna's story than even the federal agents initially understood. Her cooperation with the FBI hadn't begun with Morton's harassment of her business. It had started 8 months earlier when Agent Cross approached her with a proposition that would forever change the trajectory of her life and business. The approach had come through carefully orchestrated channels. Cross had studied her background extensively before making contact, recognizing qualities that made her ideal for the type of long-term undercover operation that federal prosecutors needed to build cases against systematic police corruption that had been operating in Baltimore for years. McKenna possessed qualifications that went beyond her MBA in business administration. Her military service had included specialized training in intelligence gathering, evidence documentation, and surveillance techniques that civilian law enforcement agencies rarely encountered. Her honorable discharge from the Army's Criminal Investigation Division had included commendations for work on cases involving corruption within military command structures. Her transition from military investigation to civilian logistics had been deliberate, motivated by desire to build legitimate business operations that could provide stability for her family while utilizing skills that transferred from military to commercial environments. But those same skills had made her valuable to federal agencies that needed witnesses capable of documenting sophisticated criminal conspiracies. When Cross first approached her, McKenna had been running a successful business with no connection to criminal activity beyond occasionally transporting goods for clients whose backgrounds she didn't investigate. Her military training made her cautious about law enforcement contact, but Cross's presentation of evidence showing systematic targeting of minority business owners had convinced her that cooperation was both patriotic duty and business necessity. The federal operation had required her to maintain normal business operations while documenting every interaction with law enforcement personnel who were subjects of federal investigation. Her shipping containers, warehouse security systems, and financial records had been modified to capture evidence that would be admissible in federal court while appearing to function as normal business infrastructure. The $200,000 that Morton claimed to have discovered in Container 7-Alpha had been placed there by federal agents as part of a controlled operation designed to document his evidence fabrication techniques. The money was genuine, the serial numbers were tracked, and every aspect of the operation had been recorded by federal surveillance equipment that Morton couldn't have detected. September 15, 2024. Closing arguments day arrived with media attention that Judge Thorne had never experienced. The gallery was packed with community members, federal observers whose presence created tension affecting everyone's behavior, and reporters whose coverage would determine public perception of Baltimore police practices and judicial integrity. The pressure was transforming routine legal proceedings into public theater, where every gesture and statement would be analyzed for evidence of corruption or competence. Judge Thorne's movements were precise and controlled, displaying behavior of someone understanding that his judicial conduct was being evaluated by agencies with power to end his career if they found evidence of constitutional violations or systematic bias. Detective Morton sat in his usual third-row seat, but his confidence appeared forced rather than natural. The defendant's legal knowledge and federal attention had transformed what should have been routine conviction into high-stakes confrontation with agencies possessing resources and authority exceeding anything available to state prosecutors. Detective Hart fidgeted beside his partner with obvious discomfort, reflecting growing awareness that their intimidation tactics had been documented and reported to federal authorities. Assistant DA Fairbanks looked pale and constantly checked her phone for messages from supervisors, trying to assess their exposure to federal prosecution for systematic constitutional violations that could destroy their careers. Ladies and gentlemen, the evidence is overwhelming. $200,000 in cash hidden in the defendant's facility. We're seeking the maximum sentence, 25 years in federal prison. Webb's closing argument emphasized the amount of money involved and severity of penalties McKenna faced if convicted, but his confidence seemed manufactured rather than genuine. The threat was designed to pressure the jury toward conviction through fear of appearing soft on crime, but his delivery suggested awareness that federal agencies were monitoring his prosecution techniques for evidence of misconduct. The threat was real. Without federal intervention, McKenna faced spending the remainder of her productive life in prison for crimes she hadn't committed. But Webb's knowledge of federal investigation was creating pressure that affected his ability to present prosecution evidence with the confidence characterizing his earlier cases involving Detective Morton's discoveries. Public Defender Emerson Vale's closing argument was predictably weak, focusing on reasonable doubt and procedural questions without evidence to counter prosecution narrative of overwhelming physical evidence and clear criminal intent. His presentation suggested resignation rather than confidence, reinforcing prosecution arguments that defense counsel couldn't explain away obvious indicators of guilt. To every observer except federal agents possessing information not disclosed to state court participants, McKenna Brooks appeared to be a defendant facing inevitable conviction based on evidence that seemed legally sufficient to support prosecution beyond reasonable doubt. Her legal knowledge had raised questions but hadn't provided alternative explanations for money that police claimed to have discovered in her shipping containers. Judge Thorne had received sealed communication from federal authorities that morning containing information about developments that would affect the day's proceedings. The contents were confidential, but his behavior suggested knowledge of federal actions that would fundamentally alter the case in ways state court participants couldn't anticipate. His constant glances toward the courtroom entrance indicated expectation of arrivals that would transform routine closing arguments into something unprecedented in his judicial experience. The federal communication had prepared him for developments that would supersede state court authority and transfer jurisdiction to agencies with different rules and more extensive resources. In a conference room 3 blocks away, FBI agents were completing final preparations for coordinated arrests that would simultaneously target multiple participants in systematic corruption extending far beyond McKenna's individual case. The federal operation had been planned for months, with her prosecution serving as culminating evidence of police misconduct that violated constitutional rights through coordinated abuse of governmental authority. Multiple agencies had contributed evidence to what was now a comprehensive federal case involving corruption, conspiracy, and civil rights violations spanning multiple jurisdictions and involving dozens of victims whose constitutional rights had been systematically violated by law enforcement personnel operating under color of official authority. What happened to McKenna could happen to anyone who doesn't understand their legal rights. Masterclass offers a comprehensive course on constitutional law and civil rights taught by renowned legal experts. Learn how to recognize when your rights are being violated, understand the legal system, and protect yourself from corruption. Whether you're a business owner, activist, or just want to understand your rights, this course gives you knowledge that could save your life and livelihood. Visit masterclass.com/law for unlimited access to over 180 classes, including legal education that empowers you to stand up for justice. At 2:17 p.m., as Judge Thorne prepared to send the jury for deliberation, the courtroom's heavy oak doors opened with sound that echoed like thunder through the silent chamber. Every head turned toward the entrance as the moment that federal agents had been preparing for months finally arrived with timing calculated for maximum impact on everyone present. The woman who entered carried herself with unmistakable federal authority that immediately transformed the courtroom's power dynamics in ways everyone present could recognize without explanation. Behind her followed 4 FBI agents in dark suits whose presence announced that state court proceedings were about to be superseded by federal jurisdiction with different rules and more extensive powers. She walked directly to the defense table with purposeful strides indicating familiarity with courtroom procedures and placed a leather briefcase beside McKenna Brooks in a gesture that announced their professional relationship to everyone observing the unprecedented federal intervention in state court proceedings. Your Honor, I am Cordelia Stone, Assistant United States Attorney for the District of Maryland. I am superseding counsel for Ms. Brooks. The announcement transformed everything that had preceded it into prologue for federal action that would determine the ultimate resolution of systematic corruption that had been operating under state court authority. Her presence announced that federal agencies had been monitoring and investigating the case with resources exceeding anything available to state prosecutors or defense counsel. Stone's appearance was the culmination of months of careful preparation involving multiple federal agencies that had been building comprehensive cases against police corruption extending far beyond individual misconduct to systematic abuse of constitutional rights under color of official authority. Your Honor, I present Federal Warrant FW-2024-8847, authorizing the immediate arrest of Detective Gage Morton, Detective Wells Hart, and Assistant District Attorney Lila Fairbanks on federal conspiracy charges. The federal warrant superseded state court proceedings and transformed the courtroom into a crime scene where the primary criminal defendants were law enforcement and prosecution personnel who had been conducting what they believed was routine state criminal prosecution. Judge Thorne's face went ashen as he realized that federal warrants superseded state court authority and that his courtroom was about to become the scene of arrests, targeting people who had been participants in proceedings he had been conducting under assumption of their legitimacy. Your Honor, these proceedings are the subject of our investigation. Ms. Brooks has been cooperating with federal authorities for the past 8 months. Stone's revelation that McKenna had been a federal cooperator for 8 months meant that every interaction, every threat, every legal maneuver had been documented and transmitted to federal investigators building comprehensive cases against systematic police corruption that extended far beyond her individual prosecution. The courtroom erupted as reporters surged forward, understanding that they were witnessing something unprecedented in Baltimore legal history. Detectives Morton and Hart sat frozen, their faces masks of disbelief and terror as they realized that their confident prosecution of what they believed was a powerless defendant had been transformed into federal prosecution of their own criminal conspiracy. Assistant DA Fairbanks dropped her files, papers scattering across the floor like snow as she understood that her prosecution techniques were not just being observed, but were serving as evidence of systematic constitutional violations that could result in decades of federal prison time. This is insane. She's a criminal. We caught her red-handed. Morton's desperate protest revealed the depth of his shock at discovering that his confident prosecution was actually a federal sting operation designed to document his evidence fabrication techniques. His assumption of immunity from prosecution had been shattered by the realization that every action had been recorded and analyzed by federal investigators. Detective Morton, you're under arrest for conspiracy to deprive civil rights under color of law, in violation of 18 U.S.C. Section 241. The FBI agent's calm recitation of federal charges transformed Morton from confident prosecutor to criminal defendant, facing penalties far exceeding anything McKenna had been threatened with under state law. The systematic nature of his violations meant that federal prosecutors would seek maximum sentences as deterrent to other law enforcement personnel contemplating similar abuses. You said this was foolproof. You said she was nobody. Hart's accusation against his partner revealed the arrogance underlying their conspiracy and their fundamental misunderstanding of McKenna's background, resources, and federal connections. Their dismissal of her as nobody had blinded them to the possibility that she possessed qualifications and support that made their prosecution tactics ineffective. Your Honor, Ms. Brooks has been documenting systematic civil rights violations by the Baltimore Police Department for federal investigators. Every interaction, every threat, every illegal search was recorded and transmitted to federal authorities. Stone's explanation revealed the scope of the federal operation and McKenna's role in collecting evidence that would support prosecution of systematic police corruption affecting dozens of victims throughout Baltimore. Her cooperation had been extensive, professional, and carefully coordinated with federal agencies that understood the value of her contributions. Ms. Brooks holds a Master of Business Administration degree from University of Maryland with specialized training in federal compliance and logistics law. She has been consulting with the Department of Justice Office of Inspector General since January 2024. The revelation of McKenna's qualifications and federal consultation role explained her legal knowledge and evidence documentation skills, while revealing that her prosecution had been based on false assumptions about her background and resources. She wasn't just a small business owner. She was a federal consultant with expertise in exactly the types of compliance issues that Morton's investigation had violated. But there was more to the story that even Stone's dramatic revelation hadn't fully disclosed. McKenna's military background included specialized training that made her uniquely qualified to document police corruption while maintaining her cover as an ordinary business owner vulnerable to law enforcement harassment. She is not a defendant, Your Honor. She is a federal witness whose life was threatened by corrupt law enforcement officials who targeted her business, specifically because they believed she was vulnerable. Stone's characterization of McKenna as a federal witness rather than criminal defendant completed the transformation of courtroom power dynamics and revealed that the entire state prosecution had been built on false assumptions about her identity, resources, and relationship with federal law enforcement agencies. The transformation was complete. The woman they had dismissed as an uneducated defendant was revealed as a federal cooperator with professional credentials that made her more qualified than her prosecutors to understand the legal implications of their actions. Your Honor, we request immediate dismissal of all charges against Ms. Brooks and the unsealing of federal indictments against the defendants. Stone's motion formally ended the state prosecution and initiated federal criminal proceedings against law enforcement and prosecution personnel who had believed they were conducting routine criminal prosecution rather than providing evidence of their own systematic constitutional violations. This court will comply with federal authority. All charges against Ms. Brooks are dismissed. Thorne's stunned capitulation revealed his understanding that federal jurisdiction superseded state court authority, and that his role in the proceedings was ending as federal agencies assumed control over prosecution of systematic police corruption that had been operating under his judicial oversight. Agent Hartwell will now present authenticated evidence of the conspiracy against Ms. Brooks. Stone's introduction of FBI cybercrime specialist Agent Peyton Hartwell signaled the beginning of evidence presentation that would document the scope and systematic nature of police corruption that had been targeting minority business owners through coordinated law enforcement abuse. Exhibit A. Audio recording timestamp August 10, 2024, 3:47 p.m. Detective Morton's voice, confirmed by voice analysis, discussing evidence placement strategy with Detective Hart. The recorded conversation was devastating evidence of premeditation and coordination in evidence fabrication that transformed individual misconduct allegations into federal conspiracy charges. Morton's voice, clearly identifiable through technical analysis, provided direct evidence of criminal intent that couldn't be explained as misunderstanding or procedural error. The audio revealed Morton discussing how to plant money in Container 7-Alpha, Hart's responses showing full knowledge and participation, and Assistant DA Fairbanks's voice coordinating prosecution strategy based on fabricated evidence that all participants knew was false. These defendants violated 18 U.S.C. Section 242, deprivation of rights under color of law, 18 U.S.C. Section 371, conspiracy to commit offense against the United States, and 18 U.S.C. Section 1341, mail fraud in the execution of false warrants and evidence reports. Stone's recitation of federal violations revealed the scope of criminal exposure facing former law enforcement and prosecution personnel who had believed their actions were protected by official authority. The federal charges carried maximum sentences that would effectively end their careers and freedom while serving as deterrent to other officials contemplating similar abuse. Mr. Webb, federal law supersedes state authority in cases involving constitutional violations. Your office has been notified of this investigation since March 2024. Stone's revelation that federal agencies had been investigating the case since March meant that Webb's prosecution efforts had been monitored for evidence of prosecutorial misconduct, while providing his office with opportunities to cooperate that had been ignored in favor of continued participation in systematic constitutional violations. There would be no cross-examination because federal evidence was comprehensive, authenticated by multiple agencies, and backed by 8 months of careful documentation. The defendants had no defense against their own recorded confessions and documented violations of federal law that had been systematically committed over extended periods. Detective Morton faces a maximum sentence of 45 years in federal prison. Detective Hart faces 35 years. Assistant DA Fairbanks faces 25 years. These are not plea bargain cases. Federal prosecution will seek maximum sentences. Stone's announcement of sentencing exposure revealed that federal prosecutors intended to use this case as deterrent to other law enforcement and prosecution personnel who might be contemplating similar abuse of official authority. The sentences would effectively end the defendants' lives outside prison while demonstrating federal commitment to prosecuting systematic constitutional violations. Our investigation has identified 47 potentially wrongful convictions based on evidence planted by these defendants. The Department of Justice will be reviewing every case Detective Morton has touched for the past 5 years. Hartwell's revelation about the scope of potential wrongful convictions meant that Morton's systematic evidence fabrication had affected dozens of victims whose constitutional rights had been violated through coordinated law enforcement abuse operating under official cover for extended periods. Your Honor, this court operates independently of any irregularities that may have occurred in evidence collection. Thorne's attempt at damage control revealed his awareness that his judicial conduct was now under federal scrutiny and that his role in facilitating systematic constitutional violations could result in federal prosecution if investigators concluded that he had knowingly participated in civil rights deprivations. Your Honor, federal investigators will be reviewing your rulings in cases involving these defendants to determine if additional charges are warranted. Stone's warning that Thorne's judicial conduct would be subject to federal review meant that his career and freedom now depended on investigators' conclusions about whether his consistently favorable rulings for Morton constituted judicial misconduct or criminal conspiracy to deprive constitutional rights. The judge's face went pale as he realized that his assumption of judicial immunity from prosecution might not protect him from federal agencies with jurisdiction over systematic civil rights violations by state court officials who facilitated unconstitutional law enforcement practices. FBI agents moved with practiced efficiency that demonstrated extensive preparation for arrests that would occur in full view of media cameras and court observers. Detective Morton and Hart were cuffed and read their rights in front of the same jury they had hoped would convict their victim, while Assistant DA Fairbanks was arrested at the prosecution table where her legal career would end. Federal marshals escorted the arrested defendants through gauntlets of media cameras, transforming the same courtroom where they had laughed at McKenna Brooks into the scene of their public humiliation and federal prosecution. Their confident prosecution of what they believed was a powerless defendant had been revealed as systematic constitutional violation that would result in decades of federal imprisonment. Outside the courthouse, small business owners who had watched McKenna's persecution gathered to witness justice being delivered to law enforcement personnel who had systematically targeted minority-owned businesses through fabricated criminal charges designed to eliminate economic competition and generate asset forfeiture revenue. Knox Thompson, Sloan Blake, Reeve Sterling, and dozens of other business owners who had faced similar harassment understood that today's events represented more than individual justice. They demonstrated that federal law provided protection against local corruption when victims possessed courage and resources to resist systematic abuse of governmental authority. 6 months later, federal prosecutions concluded with sentences that exceeded what even experienced federal prosecutors had anticipated. Detective Gage Morton received 42 years in federal prison without possibility of parole after refusing plea bargain offers that would have reduced his sentence in exchange for cooperation against other participants in police corruption. Detective Wells Hart received 37 years after providing limited cooperation that helped federal investigators understand the scope of systematic constitutional violations but didn't absolve him of primary responsibility for civil rights deprivations that had affected dozens of victims over extended periods. Assistant DA Lila Fairbanks received 28 years after her cooperation revealed prosecutorial misconduct extending beyond her individual actions to systematic coordination between law enforcement and prosecution personnel designed to target vulnerable defendants through fabricated criminal charges. All 3 defendants were also ordered to pay $3.2 million in restitution to their victims. representing both direct financial losses and punitive damages designed to deter similar constitutional violations by other law enforcement and prosecution personnel who might contemplate systematic abuse of official authority. The Baltimore Police Department implemented new oversight procedures for evidence collection and asset forfeiture that required federal oversight for all seizures exceeding $50,000. Body cameras could no longer be edited or disabled during investigations, and all seized assets required federal approval before local prosecution could proceed with forfeiture actions. The Department of Justice launched comprehensive investigation of Baltimore Police Department under federal monitoring that would continue for minimum of 5 years. 47 convictions were overturned, 11 additional officers faced federal charges, and systematic reforms were implemented to prevent future constitutional violations. The corruption had metastasized beyond anyone's initial understanding, involving supervisory personnel who had known about evidence fabrication and prosecution coordination but had protected the conspiracy because it generated asset forfeiture revenue that supported departmental operations outside normal budgetary oversight. The city of Baltimore settled McKenna's civil rights lawsuit for $4.8 million without admitting wrongdoing. But similar settlements with other victims totaled $23 million in payouts that taxpayers would fund because officials had enabled systematic corruption to operate under official cover. Brooks Logistics Solutions resumed operations with federal contracts, ensuring protection from future harassment. Her business became a model for small companies documenting their operations to prevent corruption, and she began consulting with other business owners about protecting themselves from law enforcement abuse through careful documentation and knowledge of federal civil rights law. The case attracted national attention as an example of successful federal intervention in local corruption and was cited in legal textbooks as a model for how citizens could cooperate with federal authorities to expose systematic civil rights violations by law enforcement personnel operating under color of official authority. Congress held hearings on police accountability legislation, citing the Baltimore case as evidence that federal oversight was necessary to protect constitutional rights against systematic abuse by state and local law enforcement agencies. New federal funding requirements mandated local police departments to implement federal oversight protocols for evidence collection and asset forfeiture. However, implementation varied by jurisdiction, and some departments found ways to circumvent requirements through technical compliance that satisfied federal oversight without fundamentally changing practices that enabled constitutional violations. The reform process would require sustained federal attention and continued vigilance by communities vulnerable to law enforcement abuse. McKenna was invited to speak at Department of Justice conferences on civil rights enforcement, sharing her experience as evidence that ordinary citizens could effectively resist systematic corruption through documentation, legal knowledge, and cooperation with federal agencies committed to protecting constitutional rights. Her case became a template for training federal agents in recognizing patterns of local corruption and working with community members to document constitutional violations that could support federal prosecution of systematic civil rights abuses by law enforcement personnel. She had transformed from victim to educator in the federal civil rights system, demonstrating that resistance to systematic corruption was possible when victims possessed courage, resources, and knowledge necessary to build cases that federal agencies could prosecute successfully. Brooks Logistics Solutions expanded to include federal compliance consulting for small businesses facing law enforcement scrutiny. Her experience navigating corruption made her uniquely qualified to help other business owners protect themselves from similar harassment while documenting their operations for federal protection if cooperation with authorities became necessary. That courtroom explosion was just the beginning. If you loved seeing those corrupt cops get their comeuppance, wait until you hear about the federal judge who thought he could cover up evidence in a murder case, until the victim's sister walked into court with something that made his blood run cold. Hit that subscribe button and ring the notification bell so you don't miss that story dropping next week. 2 years after the arrests, federal monitoring of Baltimore Police Department continued under consent decree that required comprehensive reforms in training, oversight, and accountability. Progress was measured but incomplete, with some officers embracing accountability measures while others found creative ways to circumvent federal oversight through technical compliance. Systematic change required generational commitment to constitutional policing and sustained federal attention to prevent regression to practices that enabled systematic abuse of civil rights. The consent decree would remain in effect until federal monitors certified that constitutional violations were no longer systematic problems requiring outside oversight. McKenna's business operated under informal federal protection. but she remained cautious about assuming that prosecution of individual actors had eliminated systematic corruption from Baltimore law enforcement. Federal prosecutions had cut down visible participants, but root systems of institutional corruption remained embedded in departmental culture that would require years to transform. She maintained detailed security protocols and federal contacts while expanding her business operations to include compliance consulting that helped other small business owners protect themselves from law enforcement harassment through documentation and knowledge of federal civil rights law. The business district slowly recovered trust in law enforcement, but healing required time and consistent constitutional behavior from new police leadership that understood federal monitors were watching for evidence of continued systematic violations. Trust had to be earned through daily demonstration of respect for constitutional rights rather than policy changes that might not reflect actual practice. The Department of Justice report identified systematic problems extending beyond individual corruption: inadequate training, insufficient oversight, and cultural tolerance for constitutional violations that had enabled systematic abuse to operate under official cover for extended periods. Addressing these issues required sustained federal attention and local political commitment to constitutional policing. While main conspirators faced federal prison, some enablers escaped prosecution through cooperation agreements or insufficient evidence to prove criminal intent rather than negligent oversight. Judge Thorne received judicial censure but retained his position after federal investigators concluded that his favorable rulings reflected bias rather than criminal conspiracy. Several police supervisors who should have detected systematic evidence fabrication were transferred to administrative positions rather than terminated, reflecting institutional resistance to accountability that federal monitors would need to address through ongoing oversight and reform requirements. Federal investigations had exposed and prosecuted the most visible corruption, but questions remained about how systematic violations had operated undetected for years and whether similar operations continued in other jurisdictions that hadn't attracted federal attention through cases like McKenna's. The institutional changes implemented under federal oversight would provide models for other jurisdictions facing similar problems, but successful reform required local commitment to constitutional policing that couldn't be maintained solely through external federal pressure. 3 months after federal convictions, McKenna received an unmarked envelope at her business address. Inside was a photocopy of a document stamped "Confidential, Baltimore Police Intelligence Division," containing a list of 43 small businesses marked for enhanced investigation through procedures that resembled those used against Brooks Logistics. Her business was number 17 on the list, but 37 others remained. The document was dated 14 months before her arrest, suggesting that systematic targeting of minority-owned businesses had been more extensive and organized than federal investigators had discovered through their prosecution of Morton's immediate conspiracy. The list included businesses that had been closed through violations discovered during Morton's investigations, but also companies that remained operational and might be facing future harassment through systematic law enforcement abuse that continued despite federal prosecutions and reform requirements. Someone with Intelligence Division access had been coordinating targeted harassment campaigns, using resources and authority that exceeded what individual detectives could have managed without institutional support that might still be operating under different procedures designed to avoid federal detection. At the bottom of the document, a handwritten note in red ink read, "Federal cooperation suspected. Subject 17. Recommend immediate action before Bureau involvement." Someone had known about her cooperation with federal authorities before her arrest, and had recommended immediate action that might have included physical harm rather than criminal prosecution. The note suggested that her federal cooperation had been detected through surveillance or informants within federal agencies, which meant that systematic corruption might involve federal personnel who had been providing intelligence to local conspirators about ongoing investigations. The timing of the note indicated that Morton's evidence fabrication had been accelerated in response to intelligence about federal investigation, which explained the sloppy evidence planting that had provided federal agents with clear documentation of constitutional violations. Who had leaked intelligence about federal cooperation before McKenna's arrest? The source of that information could still be providing protection to corruption networks that had adapted to federal oversight without fundamentally changing their systematic targeting of vulnerable businesses and individuals. What had happened to the other 37 businesses on the target list? Some might have been closed through harassment that didn't require evidence fabrication, while others might still be facing systematic law enforcement abuse through procedures designed to avoid the federal attention that had destroyed Morton's conspiracy. Which officials in the Intelligence Division had coordinated the systematic targeting campaign? The list suggested institutional involvement that extended far beyond individual detective initiatives to coordinated abuse of governmental authority that might require additional federal investigation and prosecution. Were similar systematic harassment operations continuing in other cities where federal attention hadn't yet focused on police corruption patterns? The Baltimore case had attracted federal resources, but other jurisdictions might be conducting similar operations without the federal oversight necessary to detect and prosecute systematic constitutional violations. Who had delivered the confidential document and why? The anonymous source might be providing warning about continued corruption or attempting to manipulate federal investigation in directions that served other interests. The motivation behind disclosure remained unclear and potentially dangerous. What immediate action had been recommended against McKenna before federal intervention? The language suggested possibilities ranging from accelerated criminal prosecution to physical intimidation or harm that would have eliminated her as a potential federal witness against systematic police corruption. The document raised more questions than it answered, suggesting that federal prosecution of Morton's conspiracy had addressed symptoms rather than causes of systematic corruption that continued to operate through different procedures and personnel designed to avoid federal detection and prosecution. McKenna understood that her case had been resolved, but the systematic corruption she had helped expose remained embedded in institutional structures that would require continued federal oversight and community vigilance to prevent regression to practices that enabled constitutional violations under color of official authority. Her transformation from victim to federal witness to compliance consultant had demonstrated that resistance to systematic corruption was possible, but sustained reform required community commitment to constitutional rights that extended beyond individual cases to systematic change in law enforcement culture and accountability. The anonymous document served as a reminder that her work was not finished and that systematic corruption adapted to federal oversight without necessarily abandoning targeting practices that threatened constitutional rights of vulnerable communities throughout America. Her success in documenting and prosecuting police corruption had made her a target for retaliation and a resource for federal agencies investigating similar violations in other jurisdictions. The balance between personal safety and civic responsibility would define the next phase of her inadvertent career as a civil rights advocate. The laughter in courtroom 4C had been silenced, but the institutional structures that had enabled systematic constitutional violations remained embedded in law enforcement culture that would require generational change to transform completely. Morton, Hart, and Fairbanks would spend decades in federal prison as deterrent to other officials contemplating similar abuse, but their prosecution was only the beginning of reform process that would require sustained federal attention and community engagement to achieve lasting constitutional compliance. McKenna Brooks had proven that systematic corruption could be documented, prosecuted, and punished through federal law that protected constitutional rights against state and local abuse. Her case provided a model for resistance that other victims could follow, but success required courage, resources, and federal support that weren't available to everyone facing similar threats. The true measure of her victory would be determined by whether her experience inspired systematic reform that protected constitutional rights for all Americans or remained an isolated example of individual success in a system that continued to enable abuse under color of official authority. Justice had been served in her case, but the larger struggle for constitutional rights and systematic accountability would continue long after the courthouse doors had closed on the corrupt officials who had laughed at her determination to seek truth through law. The document raised more questions than it answered, suggesting that federal prosecution of Morton's conspiracy had addressed symptoms rather than causes of systematic corruption that continued to operate through different procedures and personnel designed to avoid federal detection and prosecution. McKenna understood that her case had been resolved, but the systematic corruption she had helped expose remained embedded in institutional structures that would require continued federal oversight and community vigilance to prevent regression to practices that enabled constitutional violations under color of official authority. Her transformation from victim to federal witness to compliance consultant had demonstrated that resistance to systematic corruption was possible, but sustained reform required community commitment to constitutional rights that extended beyond individual cases to systematic change in law enforcement culture and accountability. As McKenna studied the Intelligence Division document, patterns emerged that revealed the true scope of what she had uncovered. The list of 43 targeted businesses wasn't random. Each had been selected based on specific vulnerabilities that made them ideal candidates for the type of systematic harassment that had nearly destroyed Brooks Logistics. The businesses shared common characteristics: minority ownership, moderate success that generated substantial asset forfeiture potential, locations in gentrifying neighborhoods where property values were rising, and limited resources for extended legal battles. The selection criteria indicated sophisticated intelligence gathering that went far beyond individual police work. Cross-referencing the list with Baltimore City records revealed additional troubling patterns. Many of the targeted businesses occupied properties that had been subsequently purchased by development companies with connections to city officials. The systematic harassment wasn't just generating asset forfeiture revenue. It was clearing valuable real estate for private development projects that benefited from police corruption. The economic implications extended beyond individual businesses to entire neighborhoods where systematic law enforcement harassment was being used as a tool for economic displacement. The corruption served dual purposes: generating off-books revenue for police operations while facilitating private development projects that couldn't proceed with existing businesses and residents in place. McKenna's military investigation training recognized the signs of institutional corruption that extended far beyond police departments to include political officials, private developers, and financial institutions that benefited from the systematic targeting of vulnerable businesses and communities. Agent Cross had been candid about the limitations of federal intervention in cases involving systematic corruption. The Baltimore Police Department case had required 2 years of investigation, months of undercover operations, and extensive resources that federal agencies couldn't deploy in every jurisdiction where similar patterns might be occurring. The FBI's Public Corruption Unit was chronically understaffed and faced competing priorities that limited their ability to investigate all instances of systematic civil rights violations by local law enforcement agencies. Successful prosecution required witnesses with credibility, documentation skills, and courage to testify, qualities that McKenna possessed but that weren't available in every community facing similar threats. Federal oversight through consent decrees was expensive and time-consuming, requiring sustained political will that could change with new administrations or shifting priorities. The Baltimore case had attracted attention because of its scope and the quality of evidence, but countless other instances of police corruption operated without federal detection or intervention. The constitutional violations documented in McKenna's case were symptomatic of broader problems in American law enforcement that required systematic reform rather than individual prosecutions. Federal agencies could address the most egregious examples of corruption, but preventing future violations required changes in police culture, training, and accountability that couldn't be imposed through external oversight alone. The small business community in Baltimore's industrial district had been transformed by witnessing federal prosecution of the corruption that had threatened their economic survival. Knox Thompson, Sloan Blake, and Reeve Sterling had organized the Baltimore Small Business Protection Network, providing resources and support for business owners facing law enforcement harassment. The network maintained databases of police interactions, provided legal referrals for businesses facing investigation, and coordinated with federal agencies when patterns of harassment suggested systematic violations. Their collective action demonstrated that community organization could provide protection that individual business owners couldn't achieve alone. However, the network also faced limitations that reflected broader challenges in addressing police corruption. Members who were too vocal in criticizing law enforcement practices faced increased scrutiny that could escalate into harassment. The balance between advocacy and self-preservation created tensions that limited the network's effectiveness in some situations. The success of community resistance depended on resources that weren't available to all vulnerable populations. Effective documentation required technological capabilities, legal knowledge, and financial resources that made successful resistance possible for some while leaving others vulnerable to continued abuse. The Baltimore Police Department's response to federal oversight revealed how institutional corruption adapted to external pressure without fundamentally changing practices that enabled constitutional violations. New procedures required federal approval for asset forfeitures exceeding $50,000, but smaller seizures continued under modified procedures that attracted less federal attention. Body camera policies had been updated to prevent the type of evidence manipulation that had documented Morton's evidence fabrication, but surveillance and harassment techniques that didn't require physical evidence continued under different justifications that were more difficult to challenge legally. The department had implemented new training programs on constitutional policing and civil rights compliance, but the effectiveness of training depended on supervisory enforcement that remained inconsistent across different units and neighborhoods. Federal monitors could identify policy violations, but changing the culture that enabled systematic abuse required sustained commitment from police leadership. Some officers had embraced accountability measures as opportunities to restore community trust and improve police-community relations. However, others viewed federal oversight as temporary inconvenience that would eventually be lifted, allowing return to previous practices under different procedures that avoided federal detection. McKenna's role as a federal witness and compliance consultant had fundamentally changed her relationship with her community and business environment. Her success in exposing police corruption had made her a symbol of resistance that inspired some, while making her a target for retaliation from others who viewed her cooperation with federal authorities as betrayal of local solidarity. The psychological toll of maintaining cover during 8 months of federal cooperation had required constant vigilance and emotional control that affected her personal relationships and business operations. The knowledge that every interaction might be recorded or analyzed for federal evidence had created stress that continued even after the prosecution concluded. Her military training had prepared her for some aspects of undercover operations, but civilian law enforcement corruption differed from military investigations in ways that required adaptation and personal sacrifice. The blurred boundaries between her legitimate business operations and federal investigation created ethical complexities that she continued to navigate. The financial settlement from her civil rights lawsuit had provided resources for business expansion and compliance consulting, but it couldn't restore the sense of security and community belonging that had been damaged by her experience with systematic law enforcement harassment. The consent decree governing Baltimore Police Department reform represented the most comprehensive federal intervention possible under current law, but its effectiveness depended on continued political support and adequate funding that remained uncertain over the 5-year implementation period required. Federal monitors could identify policy violations and require corrective actions, but they couldn't force cultural changes that would prevent future corruption if police leadership and rank-and-file officers weren't committed to constitutional policing principles. Sustainable reform required internal motivation that external oversight could encourage but not create. The Baltimore case had inspired similar federal investigations in other jurisdictions, but the resources required for comprehensive oversight meant that most instances of police corruption would continue to operate without federal intervention. The deterrent effect of high-profile prosecutions was limited by the perception that federal attention was exceptional rather than routine. Legislative reforms at state and federal levels could provide additional tools for addressing police corruption, but political resistance from law enforcement organizations and their supporters limited the scope of changes that were politically feasible. The balance between public safety and constitutional rights remained contested territory where progress required sustained political coalition building. The Intelligence Division document that McKenna had received suggested that systematic corruption in Baltimore had been more extensive and sophisticated than federal investigators had discovered through Morton's prosecution. The list of targeted businesses indicated institutional knowledge and coordination that exceeded what individual detectives could have managed without significant support. The anonymous source who had provided the document remained unidentified, raising questions about their motivation and access to confidential information. The timing of the disclosure suggested either whistleblowing by someone with access to police intelligence or manipulation by parties with interests in directing federal attention away from other aspects of corruption. The reference to federal cooperation suspected indicated that systematic corruption included surveillance and intelligence capabilities that had detected McKenna's cooperation with federal authorities before her arrest. The source of that intelligence could involve federal personnel, electronic surveillance, or informants within the community who were providing information to corrupt police officials. The recommendation for immediate action before bureau involvement suggested that her cooperation had been detected in time to prevent federal intervention if Morton's evidence fabrication had been more sophisticated. The sloppy nature of the planted evidence might have reflected pressure to accelerate operations rather than incompetence or overconfidence. The anonymous document served as a reminder that her work was not finished and that systematic corruption adapted to federal oversight without necessarily abandoning targeting practices that threatened constitutional rights of vulnerable communities throughout America. Her success in documenting and prosecuting police corruption had made her a target for retaliation and a resource for federal agencies investigating similar violations in other jurisdictions. The balance between personal safety and civic responsibility would define the next phase of her inadvertent career as a civil rights advocate. The laughter in courtroom 4C had been silenced, but the institutional structures that had enabled systematic constitutional violations remained embedded in law enforcement culture that would require generational change to transform completely. Morton, Hart, and Fairbanks would spend decades in federal prison as deterrent to other officials contemplating similar abuse, But their prosecution was only the beginning of a reform process that would require sustained federal attention and community engagement to achieve lasting constitutional compliance. McKenna Brooks had proven that systematic corruption could be documented, prosecuted, and punished through federal law that protected constitutional rights against state and local abuse. Her case provided a model for resistance that other victims could follow, but success required courage, resources, and federal support that weren't available to everyone facing similar threats. The true measure of her victory would be determined by whether her experience inspired systematic reform that protected constitutional rights for all Americans or remained an isolated example of individual success in a system that continued to enable abuse under color of official authority. Justice had been served in her case, but the larger struggle for constitutional rights and systematic accountability would continue long after the courthouse doors had closed on the corrupt officials who had laughed at her determination to seek truth through law.